Hello, everyone, and welcome to this episode of Inlay Terms. I am your host, Payman Ascari, and I am joined by my guest today, Miss Melissa Dore. Miss Dore, how are you?
I'm doing well, thank you. And I do want to thank you for having me on your platform.
No, I mean you and I we've been doing it back and forth over the phone, and we've been talking. And your case, it's fascinating. But I told you this. I use this phrase. It's infuriating. Like I've been angry the last few days because of what you've had to go through, and the fact that we have a government that thinks it's okay to do this to its citizens. So thank you very much for coming on.
Yes, my pleasure.
Uh, I guess I'll talk a lot on the front end, and then I'll hand it over to you. So, for the audience, Ms. Dorr has a fascinating story to tell. It's a heartbreaking story of lawfare. She suffered at the hands of the government. Before I hand it over to her, on X, I've created a script, and you're encouraged to follow along. Miss Dorr kind of knows this in and out, so she might stick to it. She might skip ahead. She might make it more interesting. But this will help you follow along the story. The other thing is, if you have any questions for Miss Dorr, you can ask it, and I'll review it at the end. Because her story is so complex, I'm going to be focusing on her the entire time. Miss Dorr, I'm going to hand it over to you, and you tell us who you are and what you've gone through the last 5 years.
Right. So I was a primary healthcare nurse practitioner. I did my bachelor's degree at the University of Windsor. I graduated in 99. I then went back to school in 2009 to become a nurse practitioner. And I was the last class that graduated with a certificate, an advanced practice certificate. And in 2019, I decided to go back and do my master's degree in the science of nursing. So that's my educational background. I worked in labor and delivery from graduation of my bachelor's until I finished my nurse practitioner program, and then after that, I practiced in primary care from 2009 right until 2021. So that's my education and professional background. I What I am here is to share my story as to what has happened to me since the COVID-19 pandemic. So in September of 2021, I had a former patient of mine approach me. He was a part of the primary care practice that I was involved in all those years. And he had asked me for help because he was very reluctant to take the COVID-19 vaccine, and his employer was mandating it. So he told me that he approached his family doctor to inquire about a vaccine exemption. And his family doctor actually told him that he was the problem and to get out of his office, implying that his concern about the vaccine was prolonging the pandemic. And so when this patient told me this, I thought it was utterly um, inappropriate for a medical professional to have that type of response to a patient. And so I went online to see what the rules and responsibilities were in terms of issuing exemptions to COVID-19 vaccines. As a primary healthcare nurse practitioner, it was within my scope of practice to issue exemptions to COVID-19 vaccines. So my quick Google search landed me on a directive called Directive 6. And this directive was put out by our Chief Medical Officer, Dr. Kieran Moore. And it was a directive to kind of guide those that employed those that were within the healthcare field. This directive encouraged employers to offer their employees three options to be compliant with the mandates. Option one was to show proof of full vaccination. Option two was to show proof of a medical exemption to COVID-19 vaccines. Now, medical exemptions were very hard to come by. By the Ministry of Health standards, you had to have a documented allergy to a component of the vaccine, or you had to have had a dose of the vaccine and had a reaction in order to be considered for a medical exemption. Now, the third option, option C, was to show proof of an education session that outlined how the vaccines worked, the safety around the development of the vaccines, the benefits, the risks, and the side effects. Important to note, though, that this directive also stated that employers had the option of removing option C. Now, as far as I know, there was not one institution that allowed for option C. Regardless, it was in print, and that was all I needed to support my endeavor. So, what I decided to do was build an education session for those that were interested in being informed about these vaccines and possibly declining based on informed consent. So, what I did was I used Pfizer and Moderna's product monographs to inform my education. So, instead of using all of the government resources that we were well familiar with, we're bombarded with public health campaigns about how safe and effective the vaccine were. I did want to offer those that I was providing an education to with the most accurate, up-to-date information. So I elected to use, again, Pfizer and Moderna's product monographs. And for those of you that aren't aware of what a product monograph is we've all seen them. Anytime you open up like a box of Tylenol, that folded up piece of paper with that tiny writing is what a product monograph is. And it's a very important document that clinicians use to decide whether or not a therapy is appropriate for a patient or not. So it's important to note as well that the vaccine product monographs at the bedside. So when people went for their vaccines and the doctors and nurses and clinicians were administering that vaccine, when they opened up that box and opened up that product monograph, it said intentionally left blank. They did not provide the clinicians who were administering the vaccines access to those product monographs very easily. However, they were online. And so I was able to pull up both Pfizer and Moderna's product monographs online. And I derived the information for my presentation from those monographs. So I delivered this online education session to anybody who was interested from September of 2021 until February of 2022. I offered this online course for free. Anybody who was interested could attend it. I did charge, however, for the letter if they chose to get the letter to prove that they had attended the education session. And the letter also communicated their choice to decline the vaccine. Now, every time I offered this session, I told the individuals that were attending that if there were financial constraints, please don't let that be a barrier to reach out to me for the letter if you need it or if you're interested in it. Because financial gain was not my purpose of offering this education session. And in fact, once they watched my presentation and participated in my presentation and requested the letter, I offered the letter before getting paid. In fact, I didn't even keep track of who paid me or not because it wasn't about money. I just had to assign a value to the course because it was a labor intensive. It was a lot of work for me to do, and it took a lot of time. So that's the only reason why I charged for the letter. So in November of 2021 was the first letter I received from the College of Nurses of Ontario, which was my professional governing body. And this letter stated that they were investigating my practice. So apparently they had received complaints from not the patients that I served, but the patients that I served were presenting their letters to. So some employers were writing into the College of Nurses of Ontario to complain. Restaurant owners that people were presenting this letter to wrote into the college to complain. And so again, very important to know that not one individual that I served had a problem with my practice.
Can I ask a question?
Sure.
And while I do, I'm going to try something new. You should not try this. There we go. So you're front and center. Directive 6, option C, proof of attending an education session.
Yes.
Did they actually specify what an education session should be?
They said it. I wish I sent it to you because you could pull up the directive. It said that the education session, it didn't. It just said it had to talk about how the vaccines work, the safety around the development, the benefits, risks, and side effects. That was the curriculum that had to be presented. The directive did say that the session had to be approved by whatever organization was allowing it, right? But I wasn't, at the end of the day, the approval of the letter came from who the letter was presented to, if you follow me, right? And so it was up to the employer whether or not they were going to accept this letter, up to the hockey arena that somebody was trying to enter, whether or not they were going to accept this letter, and so on and so forth. So again, this directive was meant for healthcare providers, but I used it as a basis to offer this program, in that education before declining was an acceptable way of being compliant with these mandates. And in fact, as a primary care health practitioner, I came across a few families over my years of practice that chose not to vaccinate their children with the mandatory childhood vaccines to attend school. And so when a parent had chosen to decline vaccination in order to allow their children to attend school, my job was to send them to an education session so that they could be educated by somebody that was a healthcare provider to ensure that they were getting accurate information in order for them to make this informed choice. So I essentially was just implementing something that was already an established practice within the province forever. And in fact, at the time, this was a novel time for all of us, and we were all trying to scramble to figure out how to navigate this. And I knew that there was no circumstance where anybody is ever to be forced to participate in a medical intervention. It's always up to the patient. In fact, that's been my education. There's something called the Nuremberg Code, in which its first rule is that nobody could ever be compelled to participate in an experiment. And quite frankly, the COVID-19 vaccines had no long-term safety data. And so we're discovering right now what happens 1, 2, 3, 4, 5 years after taking it, right? And so essentially, I had all of the my medical training and education, and actually the rules of medicine in that the patient is always, at the end of the day, has the decision to accept or decline a treatment, and they should never be punished for their choice. The only consequence for declining a treatment should be the consequence of the medical fallout or sequelae for not taking that treatment. And so that's been my understanding. That's how I've practiced all along. And in fact, that's how I understood medicine to practice all along until this pandemic.
So I'm sorry I interrupted you. We were talking about the investigation by the College of Nurses of Ontario.
Yes. So that began in November of 2021. Now, I'm going to be honest. I anticipated the college at least asking me, what I was doing. I was making sure that in everything that I was doing, I was dotting my I's and crossing my T's in preparation for the college to inquire. And so I was like, sure, I was happy to cooperate and provide them with anything that they asked me to provide them with. And so it wasn't until January of 2022 when the College of Nurses investigator and I had our first Zoom meeting. And during that Zoom meeting, I made it crystal clear what I was doing and that I was providing education, which is well within my scope of practice and actually a foundational principle of nursing, and that I was in no way stepping outside of my scope of practice. It was during that January, it was early January, I believe it was January 5th of 2022. It was at that meeting that the College of Nurses requested my slide deck that I was presenting to the public, and I was happy to present it to them. Again, I was dotting my I's, crossing my T's, and I actually made my slide presentation very scholarly, and I cited each slide to ensure that anybody that was looking at it could look up the information in the product monographs. And so shortly after that January 5th meeting, a couple of days later, I sent the College of Nurses my slide deck. And on February the 7th of 2022, the College of Nurses of Ontario placed restrictions on my ability to practice nursing, obviously stating that I could no longer teach COVID-19 vaccine education. But the most damning restriction that they put on my certificate to practice is that I required supervision to represent myself as a nurse. Now, what is significant at the time, and the College of Nurses was well aware, was that in December of 2021, at the time I was working as a medical director at a men's sexual health clinic. And what was happening was that people, my course was becoming pretty popular. And when people Googled my name, it brought them to my former employer. And so people were calling my former employer's office to inquire about my COVID-19 vaccine education session. Now, I advised my employer that I had no control over this. I had a dedicated phone number and email address for those that wished to receive information from me, and I couldn't control how people would Google and call the office. But there was no resolution sought by my former employer, and they fired me in December of 2021. And once your employment has to be updated with the College of Nurses regularly. And so again, the College of Nurses was well aware in February of 2022 when they restricted my ability to practice nursing, in that I needed supervision to represent myself as a nurse, that they were essentially rendering me unemployable because, firstly, I had all of these allegations of COVID-19 stuff, and no employer at the time would ever touch a nurse that is being investigated for COVID-19 vaccine violations. And as well, who's going to hire a nurse that requires supervision, right? And it's my deduction that the College of Nurses did this strategically so that it would be very hard for me to financially support myself during their investigation into my practice.
Can I jump in?
Sure.
I just want to pick up. So you mentioned that you suspect, we can't prove this, that the College of Nurses and Physicians did this on purpose to deprive you of your ability to defend yourself. So that's lawfare. Earlier on, I asked you, like Directive 6, subsection C, whatever it says, that to get an exemption, you have to go through a course. You were a nurse. So the college says that to get an exemption, or the directive says to get an exemption, you need to go through this education course. You as a nurse are providing this education course, and then they come after you and they say you can't provide this education course. So I'm like, what I'm trying to paint the picture, they're going in a direction where they say, we're the government, we control everything. There's an exemption, but only we will decide who can tell you, give you the education course, not you, the little people. That's what I meant when I asked you if you, who can give
very
that
accurate.
education.
Yeah.
Thank you. Go ahead.
So obviously, once they restricted my ability to practice, and in fact, before that, I think it was the end of January of 2022, I had reached out to the Registered Nurses Association of Ontario, which is a professional organization to which I was a member, to obtain help with this College of Nurses of Ontario investigation into my practice. Now, one of the features of membership of being a member of RNAO is that in the event that there is a College of Nurses of Ontario investigation into your practice, you are provided with legal assistance, essentially a lawyer to help you to defend these allegations or to help you with the investigation. So initially, I was provided a lawyer, and this lawyer on our initial meeting took the intake, took the history, became aware of what the allegations were. And a couple days after that meeting, this lawyer called me back and said that she was not able to help me any further because my allegations were related to COVID-19 vaccine violations. And so essentially, she said that she couldn't help me and I couldn't have her as a lawyer. So I just accepted that because I figured, okay, this is what it is. And so I took it on myself to try to find independent legal counsel. Now, for the next few months, I had my 2,000 plus page disclosure. So all of the information that the College of Nurses had against me. And I took it from lawyer to lawyer to lawyer, trying to obtain a lawyer to help to represent me in this investigation and to defend these allegations. And none of the lawyers would agree to take my case. So in November of 2022, a physician friend of mine had sent me a link to a hearing from the CPSO, and it was a hearing with 3 physicians that were facing similar repercussions as me for actually standing up or questioning the COVID-19 vaccine interventions that the government had implemented. So at this hearing, Michael Alexander, the lawyer, was defending Dr. Trozy, Dr. Litchku, and Dr. Phillips. And I could not believe that there was actually a lawyer standing up for people like me. And so I eventually reached out to Michael Alexander, and he agreed to help me and represent me. And I was so ecstatic. And so Michael Alexander represented me from January of 2023 until October of 2023. Now, in October of 2023, it's important to note that Michael Alexander was not successful in defending these physicians. And in fact, all 3 of them right now, 2 of them have had their license revoked, and 1 has an indefinite suspension. So he was not successful in defending these physicians. In October of 2023, Dr. Tarozi's hearing results came out, and he was not successful. So based on this, Michael Alexander said to me that if he didn't think that I would be successful in defending these allegations of professional misconduct, and he said if I chose not to plead guilty to these allegations, that he could no longer represent me. And so he essentially fired me in October of 2023. And it's important to note, my hearing to defend these allegations was to begin January 8th of 2024. And so again, I was left alone without legal representation to defend these allegations of professional misconduct. But so at that point, I said, okay, I can do this. Let me see if I can reach out to a lawyer to see if they'd be willing to consult with me, not be on the record, because clearly no lawyers wanted to be on the record to help me, but to act as a consultant to kind of guide me, to help me defend myself. And so I met with a lawyer, and he looked through my paperwork, and he said, Ms. Dore, you are entitled to a lawyer still. He said the Registered Nurses Association of Ontario never wrote you to tell you that you are not entitled to a lawyer. Again, the lawyer had the conversation with me on the phone, telling me that she couldn't represent me because my allegations were related to COVID-19, but I didn't receive anything in writing. So I wrote to the Registered Nurses Association of Ontario to say, hey, I am entitled to a lawyer, and I need that lawyer pronto because I have a hearing beginning in January of 24. The Registered Nurses Association of Ontario, they replied and said, okay, we're going to get the executive committee together on November 30th, and they will decide whether or not you can get a lawyer. So I said, okay. December 4th of 2023, again, my hearing was to start January 8th of 24. I got a letter from the Registered Nurses Association saying that the executive committee unanimously voted against me getting legal assistance. They also said that if I wish to appeal, I can write them an appeal letter. They said that the chair of the committee was in the process of drafting that the letter declining legal assistance, and I obviously needed that letter to write my appeal. That was December 4th of 2023, and we are in August of 2025, and I still haven't received that letter from the Registered Nurses Association of Ontario.
A little bit late. Yeah.
And so I knew I was on my own. So I defended myself in my hearing against the College of Nurses of Ontario really well. I think I did really well. My hearing was from January of 2024 to May of 2024. And I really did well. And so It wasn't until October that the College of Nurses rendered their decision. And on October 28th of 2024, they deemed that I committed the act of professional misconduct. I am appealing that decision. There is no way that I will ever consider that providing education to those who are interested about a novel vaccine and providing them a letter to prove the education had taken place and to communicate their choice to decline, I will never consider that to be professional misconduct. It doesn't matter what the College of Nurses says.
Can I jump in before we get to? I have two questions I wanted to ask you.
Sure.
Since my memory is horrible, I got to bring this thing up again.
Mm-hmm.
The lawyer that said that they assigned you a lawyer, but she refused to defend you because the allegations were COVID related.
Yes.
What did she say? Did she say, like, you're crazy, we don't want to represent you? Did she say, the chances of winning are very low, so in good conscience we can't take your money? Or did they say, like, it's conflict of interest because we have clients that are part of the government?
So I got no explanation other than your allegations are related to COVID-19, and because of that, you do not qualify for legal assistance. And that was the lawyer that was assigned by the Registered Nurses Association of Ontario, the professional organization that my membership was supposed to provide me a lawyer. And so if you're asking about all of I would think it was about 12 lawyers that I saw to try to get help. They all just declined and said that they were not interested. They didn't really offer a rationale or explanation. They just said that they weren't able, or they just couldn't.
I'm just trying to make sense of this quagmire that we call the government. So legal aid is when you can't afford a lawyer, the government sort of pays for it, and the government sets the rules. And apparently somewhere the government said legal aid is, if anyone's trying to defend themselves on a COVID claim, legal aid does not apply. That's probably what happened. That's what we're assuming.
That's what I'm assuming, but it wasn't legal aid. It was a professional organization to which I paid dues for 12 plus years. I should have been afforded a lawyer because, again, as a nurse practitioner, I was required to have this insurance, essentially, that they didn't allow me to use. So there's more to that story when it comes to them denying me the lawyer I was entitled to. So maybe I will go to that part. So again, I defended myself well, but in March of 2024, I decided to file a civil suit against the Registered Nurses Association of Ontario for the lack of their duty to act in good faith and fair dealing in handling my application for legal assistance. Again, I was entitled to a lawyer and they did not give it to me. And so on March 26th of 2024, I filed and served that lawsuit against the Registered Nurses of Ontario. On May 1st of 2024, now I had hearing dates on May 8th, and the final hearing date was May 14th of 2024. The bulk of the hearing took place in January of 2024. But on May 1st of 2024, the Registered Nurses Association of Ontario granted me legal assistance. This is after I served them with a lawsuit on March 26th of 2024 for not providing me a lawyer. Obviously, I ignored them giving me a lawyer. At that point, I didn't need it. The hearing was almost over. There was a day and a half left of the hearing. And so I ignored them because the lawyer wasn't going to be any good to me at that point, and because I had filed a lawsuit against them for not providing me a lawyer. And so between May of 2024 and September of 2024, I tried to engage with the Registered Nurses Association of Ontario's lawyer to move this lawsuit along. They ignored me for all of those months, and they would not participate in the legal process. So I had served my statement of claim. The next step is for the defendants to file a statement of defense, to which they did on May the 4th of 2024. And so the next step in the legal process was it was something called discovery. And it's where both parties exchange the information they intend to rely on, or the evidence they intend to rely on when litigating this case. Again, the Registered Nurses Association of Ontario refused to participate in this process. It was very frustrating. I am not a lawyer. I was self-represented. I was carrying this case by myself. And so I was super frustrated. I did some research and I found my recourse. The only recourse I had was to essentially file a motion to ask a judge to compel them to participate in the legal process, to which I did. So in September of 2024, they were finally getting back to me, and we had scheduled a motion to be heard before a judge on September 12th of 2024. The couple days before the motion was to be heard, they asked me to put the date off a little bit longer, and I refused to do so. But the Registered Nurses Association of Ontario, on their own, and they're not allowed to do this, changed my motion date to October 10th of 2024. Again, I'm not a lawyer. I have no recourse. I have no idea what to do, so I just went with it. On October 10th of 2024, we went before the justice with this case, and the justice compelled them to participate and gave them deadlines to participate in the legal proceedings. He essentially, it was at this motion that the Registered Nurses Association of Ontario first declared their intention to file a motion to strike my statement of claim, which means to throw out my case. And so the judge gave them until November 30th to bring this motion to strike my case. Now, let me backtrack a little bit. Between May and September of 2024, when the Registered Nurses Association of Ontario refused to participate, I had a lot of time to do research. And I discovered that when individuals are paid by the government, they have it's very strict, and that they cannot abuse their power to harm those that they're intended to serve. So the individuals at the Registered Nurses Association of Ontario are paid by public funds. And so there is something called the tort of misfeasance of public office. And this is when people that work and are paid by public funds deliberately use their power to harm individuals. And this essentially is what the Registered Nurses Association of Ontario did to me by withholding a lawyer that was super necessary for me to defend allegations of professional misconduct to keep my license. And so I filed this second claim for 7 figures on September 16th of 2024. With legal cases, once a statement of claim is served upon a defendant, the defendant has 20 days to respond. That 20 days came and went, and they did not respond to the second claim. So what I did was something called filing to note the defendant in default. And what that means is that the defendants essentially admit to the allegations within the statement of claim. On October the 17th of 2024, the court granted me this default, the noted in default, which means essentially the defendants have no more moves in the case and that they have lost. The only legal move that they have is to file a motion to ask a judge to set the noting in default aside. Long story short, from October of 2024 to this present day, I've been trying to receive my judgment for the 7-figure case that I filed in September and was unable to. And it is largely because of the Brampton Superior Court of Justice. Now, let me explain what's happened to me with them. So on October 28th of 2024, with the 7-figure case, I started trying to obtain the judgment. That's the paper that I need to receive my award for damages, to get paid. I filed an urgent motion, and urgent motions are to be assessed within 2 weeks. I did not hear from the court after 6 weeks. I kept going to the court at least once a week. I kept going in person. I would phone, I would email, with absolutely no response. On December 11th, I said, this is ridiculous. And I actually went to the court in person, went to the trial office, and inquired what was happening with my urgent motion. The court staff actually was quite surprised and said, this is really unusual. And they promised to have a justice look at it right away. Now, whenever I had inquired in that 6 weeks that I hadn't heard from the court, they kept saying, your paperwork, your motion materials are with the judiciary, meaning the justices had them, and you will hear from them in due course. So during that 6 weeks, for whatever reason, the judiciary at the Brampton Superior Court of Justice decided to just sit on my paperwork. So finally, on December 12th, I received a notification from the judge that they are denying my motion for judgment. They stated that I needed to serve the claim properly. Now, in the second claim that I filed in September of 2024, I named different defendants. I named, instead of just the RNAO in general, that's the party I named in March of 2024, I actually named individual defendants. There are 3 individuals. One is Mara Haas. She's the legal assistance program administrator. Ms. Wang Ya, who's the financial director at the Registered Nurses Association of Ontario, and Dr. Doris Greenspun, who's the CEO of the Registered Nurses Association of Ontario. I named those 3 in the lawsuit because those were the 3 that I dealt with via email about my legal assistance. I also named the Registered Nurses Association of Ontario's Board of Directors and the legal assistant program in general, right? And so when I served that lawsuit in September of 2016, I served 5 copies for the 5 different entities named in the lawsuit. The only thing is that I didn't hand the 3 individuals named the lawsuit in their hand. And in order for the lawsuit to be properly served, I was required to hand the lawsuit in their hands individually. Now, let me backtrack. Other than the defendants in the 7-figure case, they did not do any moves in this case at all, except one. On October 17th, the same day that the court granted me the noting in default, the defendant's lawyer served me with a document called a notice of intent to defend. The significance of them serving me with that document is that when the lawyer serves that document, it deems proper service of the individuals and entities named in the lawsuit. So essentially, the defendants were served properly if the lawyer responded with that document. So you follow me on that. Is it clear?
Well, I'm looking at this and I'm hearing 2 different things. On the one hand, it seems like some judge at the very beginning should have told you, you should either, like on day 1, they should have said you should have served them like this, or as you're saying, if it's legal for the lawyer to receive it anyway, you shouldn't have to be going through this in the first place.
Exactly. You're absolutely right. And so it's either that the judge that said I had to reserve the documents didn't review all of the filed materials. Had she done that, she would have noticed that I wasn't required to reserve the individuals in the claim. Or the courts were trying to stall me. I have no proof of either. I just know that the result was that I was required to reserve these individuals that, according to the rules of civil procedure, I did not have to. Nonetheless, I satisfied her request and I reserved the document. I only had to serve the lawyer because the lawyer was representing the defendants. And so I reserved that statement of claim, the 7-figure statement of claim, and I applied again for an urgent motion for judgment. This time I got a response right away, and the judge that reviewed the urgent motion stated that because of the unusual delays that I have received thus far, I definitely am entitled to an urgent motion, to which he scheduled on January 9th of 2025. So this motion was denied, essentially. The judge stated that I didn't submit the paperwork properly. But also what happened during this motion was it was very clear that the justice was...
Sorry, I lost you.
Yes.
So January 7th,
Yes.
they set an urgent motion for January 9th?
Yes. So what happens is that you submit your paperwork and a judge looks at it to say whether or not you're allowed to have an urgent motion or not. So this justice looked at the paperwork and said, yes, this person deserves an urgent motion, given the already 6-week plus delay that has happened without explanation. Does that answer your question?
Yeah, but then you said that something was denied. Was that denied on January 9th?
Yes. So I had my motion before another justice.
Another justice. There we go.
Yes, another justice. And it was just very obvious in the hearing that he had, there was the appearance of bias from my perspective. And in fact, he asked me, he said, "Are you accusing me of being biased?" And I said, "That's not what I'm doing right now." I said to him that what I'm concerned of is it seems as though this government affiliated defendant is getting all kinds of leeway and there's weird things happening, delaying things, and it feels as though they're being protected. And so I made that very clear to him. And but again, he denied my urgent motion. So I very quickly put the paperwork together in the way that he required it to be, and again submitted another request for an urgent motion. So on January 22nd of 2025, another justice reviewed the paperwork and said, yes, you are entitled to your urgent motion, but under 2 conditions. The first condition was that my urgent motion could not be heard before February 24th of 2025. Again, it's an urgent motion. I don't know why he didn't state any rationale as to why I had to wait 32 days to have my motion heard. The other stipulation is that all of the paperwork that I submitted to the court, which was 400 plus pages of evidence to support why I was entitled to these damages, he asked that I send them to the defendants. Now, when a defendant is noted in default, they are not required to be notified of anything, and they are not privileged to any step in the litigation other than filing a motion to setting the noting in default aside. The judge, however, has discretion as to whether or not he can order me to send them paperwork. And so they did exercise their, I guess, ability to compel me or order me to give the defendants all of the evidence I intended to rely on to support my case. So on January 22nd, 2025, the defendants were in possession of all of the evidence I intended to rely on to prove my case. And they also got a 32-day grace period without any explanation. Long story short, I said, okay, there's nothing I can do. This is what the judge ordered. I booked a motion for February 25th. He said it couldn't be heard before the 24th, so I booked it the next day, the 25th of February of 2025. Now, at this motion, again, once you're noted in default, you're not allowed to participate in the legal process. The defendant showed up on my motion, tried to take over my motion, and the judge actually adjourned my motion for judgment sine die. And what sine die means is that without a date further to be booked. Now, he adjourned this motion to allow these government affiliated defendants time to write the regional senior justice. That's the justice that's in charge of um, a certain amount of courts within the province. So it's the Central West region is the region the Brampton court belongs to. So this justice adjourned my motion for judgment in order to allow the defendants to write the regional senior justice for case management. The significance of case management is that it is one justice to preside over the case, to hear all motions. And because I had two similar cases against similar defendants, they found that it was appropriate that, well, the justices thought that case management would be appropriate for these cases. Long story short, the defendants and I both wrote the regional senior justice on March the 3rd of 2025. The defendants wrote a 2-page letter saying why case management was needed. And I wrote a 17-page letter saying how I felt that case management was not needed and, in fact, unfair. My worry was the January 9, 2025 motion judge, who was clearly biased, offered to be the case management judge. And now, if he was the judge presiding over everything, I was worried that there would be no chance for me to be successful because the judge was clearly acting in a way, at least appearing to me, to be favoring the government affiliated defendant.
Let me jump in because I'm getting really angry here. Like, noted in default, they basically, like, they didn't show up, so they lost.
Yes.
How are they still, like, how do you come back from that?
Oh, they have. So case management was assigned. Now let me say this though. The regional senior justice had the documentation from March 3rd of 2025 of the defendant requesting case management. On May 9th of 2025, the defendants wrote the court saying, hey, we haven't heard from the justice. Can you please confirm that the justice has the paperwork and is deciding on this? No answer from the court. Now, in and around April 30th, it was shortly after that, I found out that there was a public statement put out by the 3 Chief Justices of Ontario stating that they by no means stand for judicial bias, and they, especially when it comes to government affiliated defendants. I'm paraphrasing this public statement, but they put this public statement out. I was ecstatic to see that because it showed that they wouldn't stand for what was happening at the Brampton court. So on June 3rd of 2025, I took it upon myself to write a letter to the 3 Chief Justices of Ontario to inform them what was happening at the Brampton Superior Court. I also copied the regional senior justice on this letter that I wrote to the 3 senior justices. On June 3rd, we finally got a response from the regional senior justice. So I guess it took me writing her superiors or the Chief Justices of Ontario for her to actually respond. And she responded in that she is assigning case management, but she also made sure to write in her endorsement that she by no means is standing for judicial bias. So a case management judge was assigned, and on August the 12th, which was just a week and a bit ago, we went before the justice, and the motion was the defendant's motion asking the justice to set aside the noting in default. So that means to allow them to participate in the legal process again. The decision for that came out yesterday, and the justice has allowed the defendants to note the noting in default aside. So we're right back at square one, where the defendants have the legal right to defend the claim that they failed to respond to back in October.
Okay, all right. We're going to have to break that down. The defendants are the Registered Nurses Association of Ontario?
Yes.
So the judge gave them, did the judge throw them a lifeline?
A do-over. Yeah. So essentially now that they can argue the case. And now I'm going to be honest, the justice that was assigned for case management, I get the sense I don't feel just judicial bias from him. And when I actually look at the statutes, the test for a judge setting aside the noting in default is pretty low. It's not hard to achieve. And what I understand is the courts like to hear cases on their merit. So that's why he decided to allow them to argue the case. Now I will say this. It's going to be very difficult for the Registered Nurses Association of Ontario to justify why they've done what they've done. I do not believe they can be successful in defending this claim. In fact, I am very close. So I didn't speak to what happened with the case that I filed against the Registered Nurses Association of Ontario in March, claim one, right? Because I filed two claims against them. Claim one, I did say that the judge, that they were allowed to bring a motion on November 29th to strike my statement of claim. That means throw out my case. That motion was heard before a judge again on November 29th. On February 18th of 2025, we received the endorsement and the decision from the judge. The judge declined to throw out my case, and he stated quite explicitly that I had a case and that definitely the RNAO refusing to give me a lawyer could have monumental impacts on my life. So I did receive that victory, and that endorsement is public. It can be Googled and it can be pulled up. And in fact, the justice determined that this is novel. This is precedent setting. We have never seen this before. So essentially, the justice also had no problem with me filing the second claim in September, the 7-figure claim, again, citing that RNAO could be liable for doing something like this because it can cause great harm to an individual. So I have this determination by a justice that says that RNAO screwed up by withholding a lawyer. I will eventually win this case, Payman. I don't know these cases. I don't know when, but I will. And I say this because I have the statement of defense for the first claim. And in that statement of defense, the only defense that they have is I have no claim. Now, when you're litigating, you can only argue what you have in your statement of defense and what you have in your statement of claim. So I brought a motion on March 18th of 2025 to strike the statement of defense in the first claim. And I know I was going to be successful because, again, their only defense was I had no claim, and the judge deemed that I had a claim. This motion, again, was adjourned sine die in order to allow the defendants to write the regional senior justice. So I had one claim adjourned at the process where I was about to throw out their defense, which means I win. And I had the other case adjourned at judgment, which is where I collect the paper to receive my award. And so it's very clear that the Registered Nurses Association of Ontario does not have a defense for their actions, and I will be successful. Again, I don't know when, but I will be, and I'm super confident in that.
Well, hang in there. I'm rooting for you because it would make for a good precedent to actually get some wins and
Yes.
start containing this government.
Yes.
Getting to the end of the interview, I guess I just wanted to recap. So your two cases here. One, it started with the College of Nurses and Physicians of Ontario,
Not
where
physicians, just the College of Nurses. They're a separate entity than the College
sorry,
of, yes.
the College of Nurses of Ontario, where they made you unemployable.
Yeah.
And then the second series of cases was against the Registered Nurses Association of Ontario when they refused to defend you against the College of Nurses.
Or issued me a lawyer that I was entitled to defend my allegations. Yeah.
Right. So it was one issue that led to another issue. So I might have gotten lost in all the minutia here. What exactly did happen to the College of Nurses? Did you ever get any victories there?
Absolutely. So again, October 28, 2024, they deemed that I had committed the act of professional misconduct. March 24 of 2025 is when we had my penalty hearing. And that is when they decided to permanently revoke my license to practice nursing. I will never be a nurse again in Ontario. And once you have your nursing license revoked in one jurisdiction, it's going to be very hard to get a license in any other jurisdiction. So because I provided education and a certificate to prove that, I can no longer be a nurse. This is what's happened to me.
Again, I'm beating a dead horse here, but the government, first of all, the government takes over these college of physicians. It's a regulatory body. So if in order for you to be able to practice nursing, you're at the discretion of the government. The
Yes.
government passes a law that says, Directive 6, subject to this exemption, you need to go through an education course. And then you as a nurse go through that education course, and they say that you are, what do they call it? Professional misconduct?
Yes.
So professional misconduct is like if your patient is passed out and you take liberties with that patient, or you're drunk on the job or something. Not if you give an educational course using that piece of paper that's folded into the Tylenol bottle.
Yeah, it's been insane. And in fact, I've had a lot of time to look at other nurses that have had their license revoked, and it's for things that are quite obvious they deserve their license to be revoked for. But I have yet to find a case where a nurse provided education to the public that was interested in this education, especially in information that was quite sought after for a novel product. But yeah, it's been my situation. But again, I honestly feel that I'm on a journey. God has given me the strength to get through this, and I've lost everything. I've lost everything. My home, cars. I've been without a fixed address for more than a year and a half, and I have absolutely no regrets, payment. Absolutely no regrets, because I helped people exercise the right to decline a novel vaccine through informed consent.
And just for the audience again, you didn't do it by making some claim to some spiritual realm. You just opened up you got it off the internet, but Pfizer's own paperwork, and you just everything you taught them, you deduced from that.
Absolutely.
Well, I'm very sorry for the fact that the government's come after you for this. They're to make an example of you, but you're one tough cookie, and keep at it, and I'm sure you'll find success.
Thank you. Thank you so much for the opportunity to share my story, and I really appreciate you. Thanks. Thanks again.
No worries, Miss Dore. I'm going to hold you over until after the episode, but again, a big thank you to you, a big thank you to the audience, and this is hopefully together we can get through this as a country.